Good morning, everyone.
Court back in session.
Calling the case of Wren versus Affinity and Carrier versus Affinity. Do we have an appearance in the courtroom?
We do. Good morning, Your Honor. Samuel Merkovich, Campbell and Williams, appearing on behalf of the Carrier family.
Thank you.
Good morning, Your Honor. Eric Pepperman, on behalf of the Wren family.
Good morning, Your Honor. Mike Hetey, bar number 5668, on behalf of Real Water Inc. and Affinity Lifestyles, DBA Real Water.
Good morning, Your Honor. Philip Goodhart, bar number 5332, also on behalf of Real Water.
Is that everyone who's appearing? All right. I've called both cases together because they appear to be related, but I would, unless there's objection, I would argue the Wren case and the Carrier case and then have one opposition, unless there's objection. All right. So Mr. Merkovich is here, so let's take the Carrier case first and then the Wren.
Your Honor, if the court wouldn't mind, I think it might make sense to take the Wren case first, and I say that because Mr. Pepperman and the Kemp Jones firm has actually sought its relief prior to the Carrier family and has also been seeking the same relief from several other departments. So if it's okay, I'd let him take the lead as we're kind of coming in second.
Absolutely. Mr. Pepperman.
Yes, Your Honor. Thank you. I think the background is spelled out in the motion, but essentially the FDA is conducting an investigation into the outbreak involving Real Water. Our clients, the Wren family, were part of this outbreak. Their young son was one of the children who was sent to Primary Children's Hospital in Salt Lake City with liver failure, and was one of the group of kids who kind of jump-started the investigation into it. My clients have a sealed 5-liter bottle of Real Water from around the time that the FDA is looking at, and I believe it's November or October of last year. And the FDA has requested that the Wren family provide that sample and any other water samples that they have in their possession. I believe they have an unopened bottle or an open bottle as well. I've been in contact with the FDA investigators and general counsel for the FDA on this issue, and I've explained to them that we don't have a problem providing them with the samples in our client's possession as part of their investigation for testing as they request. But because it's evidence in a lawsuit, we thought that the most prudent way to handle it is to first get court authorization and give the defendants an opportunity to weigh in before we provided it, just so everyone's interest can be preserved. As Mr. Merkovich said, we've filed several of these cases in various departments in addition to this one, and in many of our cases, the FDA has made similar requests for samples in our client's possession. And as we're doing in this case, we took the same steps to first seek court authorization and give the defendants an opportunity to weigh in. We've had hearings in front of Judge Gonzalez and Judge Williams on this similar issue. In the Judge Gonzalez hearing, which was in the Hunwardson versus Real Water case, representative and counsel from the FDA appeared and weighed in. The FDA has represented that if they're allowed to take possession of the samples, they would provide a chain of custody. Of course, they would take the samples directly from our clients or our possession. They would transport the sample to their forensic laboratory in Cincinnati, Ohio. They would where they would perform the testing at their internal lab. With respect to the 5-gallon samples, the FDA is advised that their testing would only use about half of the water, and that the remaining half of the water they would provide to the parties for their independent testing. Both Judge Gonzalez and Judge Williams has authorized us to provide the samples to the FDA under those terms. In the prior two hearings on this issue, Real Water was represented by different attorneys, Charles Labello and Craig Mueller. They were in the process of retaining coverage counsel. So Mr. Hetey and Mr. Goodhart today, this is the first time that they've been retained. So I just want to make the court aware of that change. Otherwise, we're really seeking the same relief that we were seeking in the other cases, and that's simply authorization under whatever terms the court deems appropriate to allow these samples to go to the FDA for testing as part of the FDA's ongoing investigation.
And Mr. Pepperman, did you also want to request relief directing the defendants to preserve and catalog evidence and products?
Yes, Your Honor. This is one as well that is Judge Gonzalez and Judge Williams have also ruled. Essentially, Real Water has been there's been a recall of the water, and as part of those efforts, they have been going to the homes where they've delivered water as part of their home delivery service and trying to retake possession of the water. Several people have provided the water. Some people have declined to provide the water. Our concern is just that for the water that Real Water has been able to collect, and to the extent that they are continuing their collection efforts, that those samples are preserved somewhere where as we get into discovery, we'll be able to have the option to know what homes they were collected from and the conditions that they were preserved, or make sure they're available for use in case they're potentially relevant in this case or any other case, and be able to identify where they collected that water from. So I do believe that is an important order to include in this case, but it is not something that Real Water, we're not asking for anything that Real Water hasn't already been ordered to do by Judge Gonzalez and Judge Williams.
Thank you. And is there a response?
Yes, Your Honor. Mike Hetey. First, I was not aware of Mr. Labello's representation. I was aware of Mr. Mueller. He and I spoke yesterday. We were contacted by an insurer for Real Water who engaged our firm. So we are endeavoring to get up to speed as fast as possible. And to that extent, I knew there was a hearing, but I was told it dealt more with preservation of meters than issuing an order that may or may not mimic what is requested in the order or requested in the moving papers here. We do not oppose allowing the water samples to be either retrieved by the FDA. It sounds like they're going to come and get the samples. We would just ask that there be a protocol in place so that not just the water, but also the bottles, the caps, all of that would be preserved. And I anticipate the FDA would have no issue with that. And to that end, I can tell you that Jennifer, I believe it's this morning to talk about it. And she stated that they were looking for samples on the order of a gallon, potentially more if there was more, and that they would use half and then preserve half so that the parties could test that remainder. Whether that's enough, I'm not positive now. I think that's probably going to be an expert issue. But it sounded like she also was expecting there to be some written test protocol that the parties were going to be working on together. And maybe Mr. Pepperman or Mr. Merkovich can weigh in on that if there's one in development. But it sounds like FDA this morning that they are expecting some type of written protocol that everyone can agree to, and we'd be happy to participate in that process. So on the point one of evidence and allowing the FDA to test it, we don't oppose that. Part two on the issue of what has been retrieved from customer homes, I unfortunately am at a disadvantage. I don't know what has been retrieved or how what has been retrieved before any order of Judge Gonzalez or any other court. I don't. What we can say is that if the court going forward wants the real water parties to catalog in this manner, we will certainly request that they do it because it doesn't seem unreasonable. I just don't know what was done before now. So I can't say whether product that may be in their warehouse, which is where I'm told it is, I don't know if there is a chain of custody that links a particular bottle to a particular home where it was retrieved from. So subparts little I and 2I under part 2, if you look at the motion on.
Mr. Hetey, did we lose you?
We would endeavor to obtain that data. Those were the only 2 points that could be difficult to comply with should the court issue that order. So if there is an order, we would ask that it be, to the best of the defendant's ability to comply with that element of the request.
Thank you. And the response, please, from Mr. Pepperman.
Well, Your Honor, on terms of point one, it sounds like we're in agreement. The way that has been similar to the prior hearings, and the way that we handled that was when the court granted our motion, we met and conferred over the proposed order to include the protocol. And I'm happy to do that in this case with Mr. Hetey and work with the FDA to establish the protocol of how the FDA is going to collect the samples and what they're going to do and how they're going to return them and all that information. I don't anticipate us having an issue agreeing on that. And assuming we could just submit the proposed order to the court containing our agreed terms and on the protocol. And if there is a disagreement, we could, seek further clarification from the court on it. On part two, and I would propose we handle it the same way here, if that's acceptable with Your Honor. Part two, certainly, you can't go back in time and change what's already been done. To the extent that the information exists, we would request an inventory report containing whatever information they have on how the previous samples were collected, and if they relate to if there's an existing chain of custody of where they were collected from, and if that information doesn't exist, a statement to that effect, letting us know, and certainly clear understanding that they were required to maintain that information at least going forward.
Okay. With regard to the Wren motion, the argument has now concluded and the matter is now submitted. There being no opposition by the defendant, the motion will be granted in all respects. First, to allow to give the plaintiffs the authority to work with the FDA according to a protocol that will be in place, in which the defendants will have input for testing and analysis of water in the possession of the Wren family. The second part of the motion will also be granted. The defendants will be directed to preserve and catalog the evidence that they have now, consisting of the products in the warehouse or elsewhere, wherever it might be, to include an inventory, and that the parties will work cooperatively on preparing an order granting this motion. If there are any snags in the language of the order, notify me and I'll conduct a telephonic hearing on that. Then I have Mr. Merkovich who wanted to say something.
I did, Your Honor, and I don't know if this was in the Wren motion or not. I suspect it was, but it's certainly in ours, which is a third component to the order.
I'll take yours separately.
Okay,
Because you rushed the ORP
exactly.
meters,
That's right.
and we'll deal with that because that wasn't included in the Wren motion.
Understood, Your Honor.
So now, input from both sides with regard to the ruling. Are there any questions?
And from the defense, this is Mike Hetey.
Good enough. So
None.
Mr. Pepperman will prepare the order. Defense counsel will review and approve the form. I do not accept competing orders, so if you have issues with the language, bring that to my attention through the JEA, and I'll conduct a telephonic with regard to that. Now let's take the second motion, which is from the Carrier family, and that would be Mr. Merkovich.
Your Honor, as the court is aware, we've requested the same relief as the Wren family, and so I don't have anything to add as to points 1 and 2. However, as we just figured out, there's a third component that he had requested through our motion that was not requested in the Wren family's motion, and that is for the defendants to stop using ORP meters or ORP meters at their Henderson and Arizona facilities. From the other hearings wherein that relief was requested in front of Judge Gonzalez and Judge Williams, they both courts issued orders ordering Real Water to preserve those meters. Mr. Craig Mueller, on behalf of Real Water, had represented to the court as recently as Monday. He's obtained both meters. He's kept them preserved at his house. So essentially, I think what we're asking the court is for the same order as in those other matters, and to just maintain the status quo, which is that either Mr. Mueller transfers those devices to the Thorndale Armstrong firm for the time being, or continues to keep them safe and secure at his office until the parties can get a joint evidence warehouse established, which I know is in the works, and then we can deposit those items there.
Thank you.
Thanks.
And is there a response from the defendant?
Yes, understanding the relief that's requested to the extent it's identical to the prior motion, we would have the same arguments or same statements. And then with respect to the ORP, I did meet with Mr. Mueller yesterday. He showed me a box and he stated that inside of it are 2 ORP meters. I did not ask whether one was from Arizona and one was from Nevada, or whether they're both from Nevada. So I don't know the answer with certainty today, but I do know there are 2 meters that he told me are within this sealed box with a document that purports to be a chain of custody, and it is at his office downtown here in Las Vegas. So we are happy to work with the parties and agree upon a protocol, whether that's transportation to our office or I'm told there's going to be an agreed upon warehouse of some sort where evidence may be stored for this case. So one way or another, we will work on that with everybody to make sure that evidence is transferred and preserved appropriately.
Thank you. And is there a reply?
Yeah, Your Honor, I think we're all on the same page.
Good
Thank you.
enough. So with regard to the Carrier case, the relief will be granted in all respects with regard to the FDA with same provisions as the Wren case. With regard to the preservation of inventory, same protocol as the Wren case. And with regard to the third prong of this plaintiff's request, the ORP meters, the defendants will be enjoined from using them any further, will be ordered to preserve them and to work with plaintiff's counsel with regard to a protocol for their storage. Okay, and Mr. Merkovich to prepare the order. Mr. Hetey and Mr. Goodhart, do you wish to approve the form of that order?
Yes, Your Honor.
Good enough. And then if there's any disagreement with regard to the language, again, I don't accept competing orders, but bring that to my attention through the JEA, and I would set a telephonic at my earliest convenience.
Thank you, Your Honor.
And thank you all for your appearance today.
Thank you, Your Honor.